Welcome back to another episode of Ex-Ante. Today we're going to discuss the case of Tarasoff versus the Regents of the University of California. This case was argued in the California Supreme Court in the year 1976. Let's go ahead and jump into the facts. So, Tatiana Tarasoff was a student at the University of California, Berkeley. While she was there, she came in contact with a man named Prosenjit Poddar. He was quite a bit older than her, and he was a student here in the United States of America from India, studying on a visa at the University of California, Berkeley. Poddar began to show interest in Tarasoff, so he began to kind of talk to her a little bit. They had a small relationship with one another. Ultimately, Poddar was much more interested in Tarasoff than she was in him. Tarasoff had gone to Brazil for the summer, and while she left, Poddar became depressed, so he went to a therapist and began to seek some treatment for his depression. While he was at this therapist's office, and the therapist is underneath the University of California system, that's why they are named as the defendants in the case. This therapist, Dr. Moore, was seeing Poddar, and Poddar expressed to him that he had a desire to murder Tarasoff while they were having their meetings. Moore was obviously concerned when he heard this, so he went ahead and told his superiors, and they recommended that they confine Poddar for a few days just because of how concerning his statements were. Ultimately, he was confined for a few days before he was released back out into the public, just in time to actually go and murder Tarasoff. So he killed Tarasoff after telling his therapist that it was his intention to do so. They locked him up for a brief period of time. When he got out, he actually did indeed kill her. It's a tragic story. The Tarasoff family was obviously frustrated when they heard that Poddar had gone to a therapist and discussed the issue with the therapist, and the therapist ultimately let him run free and didn't tell Tarasoff about anything that had been expressed to him by their patient, especially his motives to murder their daughter. So they brought suit. There's a variety of claims, but the claim that I want to focus on, the claim that the decision of the court focuses on the most, is a duty to warn. So the family claimed that the doctors had a duty to warn Tarasoff about the danger that was coming to her life from Poddar, and they didn't do that. So the issue in this case is whether psychotherapists have a duty to others that aren't their patients, whether harm caused by their patients to others, they can be held liable for that harm caused by their patients at a certain level, especially if it's been expressed to the psychotherapist by the patient what they're intending to do and the harm that they're trying to cause. So the ruling of the court does say that yes, psychotherapists can be held responsible for the harm their patients cause to others if they do not warn the party that could be harmed by their patient. So since Dr. Moore of the University of California medical system didn't warn the Tarasoff family, more specifically Tatiana, the daughter that was murdered, about the threat to her life from Poddar, they were able to be held liable for negligence in this tort case. Quote the court's decision where they say, by entering into a doctor-patient relationship, the therapist becomes sufficiently involved so as to assume some responsibility for the safety of the patient, and also any third person whom the doctor knows to be threatened by the patient. So you can see very clearly the third person threatened by the patient in this case was Tarasoff. All right, so let's go ahead and jump into some of the ex-ante implications of this case. The first one that I want to discuss is therapists being more choosy of the patients that they decide to take on and give their services to. They might limit or have a pre-screening ahead of allowing them into their therapy clinic, where they see if these clients might have any violent tendencies. And if they do have violent tendencies, they might not let them in to their clinic because they don't want to be held liable for any violence that comes as a result of their violent acts in the future. This is kind of scary and has negative consequence, because if we have a lot of violent actors that aren't able to see therapists, they might be more and more likely to actually cause damage in the future because they didn't get the therapy that they needed to have. Perhaps if Poddar hadn't received any therapy, he might have taken a gun to the University of California, Berkeley library and shot multiple people rather than killing an individual, Tarasoff. So we can't say that for certain, obviously, but if violent actors and those with violent thoughts aren't able to get therapy, it's much more likely that they're going to act out their violent thoughts and cause more harm to the world. So that's first ex-ante implication. The next would be patients might undershare with their therapist, so they might not share all of the details and the violent thoughts that are actually deep inside of them because they don't want to implicate their therapist for anything that they share with them. It just would lead to less effective therapy in the long run as patients undershare and don't share their true feelings inside themselves. Next ex-ante implication I want to jump into is it's a hypothetical. If Poddar was violent towards himself and had suicidal tendencies and visited a therapist and he expressed to that therapist that, hey, I want to, end my life, something tragic, I just can't go on anymore. And that therapist didn't in turn warn Poddar's family about his own violence toward himself. Could that therapist be held liable for a failure to warn the family about the violence that Poddar was going to do to himself? An interesting hypothetical. Perhaps this case could be applied to argue that a therapist has a duty to warn family members about a suicidal individual that is receiving therapy. Finally, I just want to think about how far this duty to warn can be extended. The court specifically talks about a doctor-patient relationship, but could this philosophy and precedent be extended to maybe a work manager, or we hear about life coaches a lot now, or even just a close friend? Is there this duty to warn because of this close relationship? Could that be argued and turned into something more than just a doctor and patient? Is it just a close relationship that constitutes a duty to warn? A few things to think about, chew on and digest. Thanks so much for watching. I hope you have a nice rest of your day. If you have any other ex-ante implications, feel free to leave them in the comments section below. And bye-bye now.